Good morning and welcome. Naina referring to the impossibility of testing decisions in international tribunals by any democratic means allows me to just explain to you something that will be explained but more by Tatiana, who's just walked out, tomorrow. This place, Pro Demos, is an important part of Dutch culture which may not be replicated in other countries, because this is concerned with educating and getting the participation of people from the age of 10 upwards in the democratic processes of this country. And that's why there's rooms like this, and you'll see other rooms that are replicas of other rooms in the parliamentary process. You may also see in the building today young people in their university age who are learning the process of becoming peer educators for others. This is more than that awful modern word, outreach. This is a process of active encouragement and engagement in the political process. My few minutes are going to be devoted to political expediency. Last night, those of you who were at the book launch will have heard me speak of some of the worst examples of political interference in the judicial process of the Yugoslav tribunal, and I'll summarize those at the end of what I have to say. But I thought that it's worth observing that political expediency can be big P political, and it can also be small p political. And what's the characteristic that joins both of them is that none of them is necessary. It's very strange that the rule of law actually operates very well. You can be completely open, you just follow the rules, you do your job, and there's no problem. But with these international tribunals, where perhaps because so much power, unelected, unaccountable power, is given to people like the chief prosecutors or the presiding judges of the appeals chamber, power goes to people's heads, and they feel it must be better to engage in manipulation of the result rather than in following the rules and having a rule of law result. And I'll just give you a couple examples in addition to what I told you yesterday, and will summarize, of internal misbehavior, really, within the courts. Tatiana, I gave the 1 minute of introduction, and you'll tell us more about your wonderful institution tomorrow. Thank you. When I first went to the ICTY, I was asked, apart from the case I was retained to do, to prosecute a short case called Jelicic. And Jelicic was a low-level, in the management chain, very low-level killer. He'd been given a police uniform and a gun, and he killed a whole lot of people at Brčko in the most appalling circumstances. And he was unwise enough to be photographed doing it. The photograph made it to the front cover of Time magazine. And what he did was he killed a whole lot of people outside the police station. This is where he was photographed killing them, after they'd had entirely nominal interviews by the Serbs who were taking over the town. And so this was the leadership of the Bosnian Muslim community in the town in which they had a majority, Brčko. And so he killed them, and then he was put in charge of a warehouse down on the Sava River, where he, for a few weeks only, conducted an utterly extraordinary killing campaign that could be observed by people looking out from the warehouse. He took people out, made them put their heads on top of the drain, blew their brains out, so that the mess was slightly less than it might otherwise be, and summoned people out by list so that people inside the warehouse were in a state of absolute terror, taken out and killed, loads of them. And indeed, it's an interesting psychological reality of what happens in these circumstances, that when Jelicic was finally stopped from what he was doing by his own side because of the excesses, the people in the warehouse put him on their shoulders and carried them round in a sort of a victory parade. Funny, horrible business. In any case, he was arrested and he was brought to The Hague, and Louise Arbour was then the prosecutor, and she charged him, amongst other things, for his killings with genocide, because he said the most awful things about Bosnian Muslims when preparing them for their fate. Now, of course, tomorrow we're going to hear, I think, on the wisdom or otherwise of having a crime of genocide and of charging a crime of genocide, but let's not worry with that now. It was in Louise Arbour's armoury, and she charged it. She was then under some pressure, I'm not quite sure how it was applied, to drop the count of genocide and let this low-level killer be charged with and probably plead to the other forms of killing that were listed against him. Where's my watch gone? Oh, there it is. She resisted that, and the trial went ahead. The prosecutor had to leave for very sad family reasons. I took over. We reached the end of the prosecution case, and the defense counsel said, well, are you going to argue that there's not enough evidence for genocide, which is the sort of argument you might expect at the end of the prosecution case? He said, no, I'm not going to argue that. So there was then a gap, and then we heard that the court was going to announce its judgment. This was clear. They were going to acquit of genocide. So we wrote them various filings saying, can we please be heard on this? Can we argue that there is enough evidence? Silence. There was then a hearing. By now, Louise Arbour had left, and too early for the good of the institution, to be replaced by Mrs. Del Ponte. I went into court on the day that judgment was going to be given, and I stood up to ask the court whether I could please be heard on the fact that there was indeed sufficient evidence for genocide to go forward. It was a bit, it's one of my greatest moments of adversarial showing off, I suppose, really. It's used as a tool of what to do, and what not to do, rather, I think, in advocacy training. Sit down, said Judge Jourda, the French judge. So I didn't sit down. I said, sit down. I felt a bit like somebody out of a Dickensian novel asking for more. Can I have some more time, please? So, no, sit down. So eventually, feeling rather humiliated, I sat down and engaged in what was my greatest and single piece of advocacy that day, which was to cast my spectacles in disdain on the desk. He'd promised me that I'd be allowed to be heard immediately after they gave the judgment, which was, by the way, indecipherable, incomprehensible, and without any validity, and far from giving me a chance to speak, ran from the court, lest anybody should catch them. Now, the following day, a friend of mine bumped into one of his colleague judges. There were 3 judges, very nice judge, called Fuad from Egypt. And Fuad said to my friend, he said, you know, we thought he was guilty of genocide, but we wanted to keep the case for a bigger fish. Well, we guessed that was what they were on about from the beginning. And indeed, ultimately, we succeeded in, on appeal in a judgment that, although it didn't order a retrial, said, yes, we were right. There was enough evidence for genocide. Yes, we should have been allowed to be heard. But by the time all this happened, Mrs. Del Ponte had gone and seen the presiding judge on her own. I said, don't do that. The senior prosecutor shouldn't be meeting privately with the presiding judge of the court. She took no notice of my advice then, or ever, really. And we always thought that she'd been under pressure at that moment to drop the genocide appeal in exchange for a heavy sentence. And certainly, Jelačić got a heavy sentence, and maybe we were right in that guess, because the presiding judge, Judge Jourda, at a later stage, joined Jelačić in his application to have his sentence reduced. This was a completely unnecessary bit of internal expediency pressure. For some reason, the court didn't want a junior figure to be convicted of genocide. If they didn't like her, Louise Arbour's or Del Ponte's later indictment policy, they could have dealt with the matter openly and publicly. They didn't. These courts are wont to engage in this sort of back-scene manipulation, and it's quite wrong. The second example, which I've only just got time to mention, is a much worse example, where towards the, with 7 days left of the prosecution case in the Milosevic case, we realized that the presiding judge, Judge May, was very ill. Indeed, he was so ill he was never going to come back to sit again. There were 7 days of evidence left. The rules of the court said you can sit for 5 days with only 2 judges if the 3rd judge is only away for a reason of short duration. Untrue. He wasn't away. He was away forever. He was never coming back. The case had to stop there and then. But what happened was that Del Ponte, in cahoots with the presiding judge, Meron, who is still the presiding judge of the residual mechanism, conceived of a plan to squash the 7 days of evidence that was left of us in the 5, and never to tell a soul about the fact that Judge May was ill, and in particular, not to tell the defendant. They conceived this plan. When I resisted it, they summoned me, that is, the chief prosecutor and the presiding judge, with a note taker trying to terrorize me into behavior. And they had told me at one stage, it doesn't matter if we are wrong, we'll just call the evidence, recall the evidence on a later date. And I resisted all this and said, no, you can't do that. I spoke to my professional body in England, and they said, yeah, of course you can't do that. You've got to tell Milosevic enough about the defendant's ill health for him to know that the proceedings that are about to start are unlawful. And it was a terrible showdown with Del Ponte. She didn't want to accept that there was ethical principles driving it. She just wanted some kind of PR coup, whatever it was, to finish the prosecution's case without revealing that, unhappily, Judge May was that ill. And then Judge May was replaced by Judge Bonomi in due course, who read himself into the case and took over. There's more I could tell you about that, but it was another terrible example of internal expediency, completely unnecessary. And then the 3 examples I gave you last night, which some of you at the courses will have heard of before, were 1, Del Ponte doing a deal with Serbia to blank out from public view critically important documents. 2, Del Ponte apparently having done a deal with Serbia that led to her indicting the Prime Minister of Serbia, Kosovo, when there was no evidence against him, and when people were brave enough to tell her there was no evidence against him, and they were proved to be right because he was acquitted not once but twice. And then 3rd, the really more serious example of the United States of America walking in and stopping me getting hold of evidence of intercepts between Milosevic and Mladic at the time of the Srebrenica, all probably consistent with the West being complicit in the takeover and indeed forecasting the massacre at, or at least some of the killings at Srebrenica, and not wanting that truth known, although the evidence of what passed between Milosevic and Mladic plainly being evidence of the greatest importance. Politically expedient, all unnecessary, and done because these courts don't know how to behave. We'll come back to that more because it's time to start with Andrew Cayley.
Absolutely, but before we finish, I hope I can comment in a general way. I think this was a wonderful example why lawyers do need us, non-lawyers, because Sir Geoffrey demonstrated this whole academic debate that we have so many examples from the practice, what's happening. But if I would ask Sir Geoffrey, for example, where would you place in a more abstract, theoretical way, or even in our small little conceptual groups today, your experience with due process and the crisis after Judge May's health was identified? How would you conceptualize it in a more broad theoretical principle? Because, you know, having one example after another is fabulous, and it's very interesting, and we are all very excited. But if we need to make a theoretical point, what would we do? You don't need to answer now. It's just a very interesting example, I think, how these things work and how they should work.
And I'll answer it in 30 seconds because it is a very important point. It looks pretty trivial, doesn't it? You know, why not fib a bit about whether Judge May's unwell? The evidence is going to come in the end. Does it matter? Well, anyone, and there are plenty in this room who's worked in legal systems such as the British system, not the best system in the world, but has its advantages and disadvantages, knows that the first step down that path to misbehavior, not producing the evidence that should have been produced at famous IRA trials in England and that led to them going wrong, not producing evidence to defendants in recent rape trials that should have been produced, interfering with the integrity of a known legal process is something you do at your peril, because if part of the process is infected, the public who have to have trust in it will distrust all of it, and that's the principle.